Good morning, everybody, and welcome to today's session. We are allowing all the participants to enter the room, so thank you very much for waiting a few seconds.
Laura, you can make me co-host if you like to. Again.
Sure. So thank you very much, everybody, to join us today in this session called Drafting Sales Contracts when Exporting to China. We are going to have today Mr. Suleiman Karakaya as representative of the Istanbul Chamber of Industry to welcome you all to this workshop. Suleiman, the floor is yours. Suleiman, can you hear me? Hello, Suleiman. We might have a technical problem with Suleiman. He's not responsive right now. So instead of having him welcome you, we are going to turn the things and start presenting the EU SME Centre. And in the meantime, we hope that Suleiman can join us again. Oh, Suleiman, you're here.
Sorry about the inconvenience.
No problem. Suleiman, the floor is yours to welcome the participants.
First, I want to welcome everybody in English. Thanks for joining us. We are here to very happy to make this event with EU's China SME Centre. It's also our first event as Istanbul Chamber of Industry China desk. So I hope everybody will enjoy it. I don't know. I just disconnected from the event lately. I don't know if Laura made the announcement, but we have interpretation today. For the English speakers, please choose the English channel always if you want to hear in English. And for the Turkish speakers, please always choose the Turkish in the interpretation below the screen. So I will make this announcement in Turkish again for who missed it. Lütfen Türkçe konuşan misafirlerimiz Türkçe kanalından çeviri dinleyebilirler ve her zaman Türkçe kanalında kalmaları gerekiyor. Sorularınız olursa chatten bana özelden de yazabilirsiniz. Sonradan ISO Çin masası aracılığıyla da bize ulaşabilirsiniz. Teşekkür ederim. Thank you very much. Floor is Daniel. Thank you.
Suleiman, I will introduce Danielle together with a small presentation of the EU SME Centre we do all the time, just for those who don't know about us and about what we do and how we can help you to enter the Chinese market. I will be very brief, as I'm sure that you are looking forward to hear what Danielle has to say today, so please bear with me. I'm going to start sharing my screen right now. I hope you all can see it very soon. Suleiman, can you confirm that you can see the screen?
Yeah, I can see the screen.
Perfect. Thank you very much. Here we are. So the EU SME Centre, for those who don't know about us, is a EU-founded project that started in 2010. So it's already 11 years that we are here helping European SMEs to access the Chinese market. We are currently on the third phase of the project. We had two phases before. Now we are running until March 2022. And our goal is to prepare companies by providing a wide range of information, advice, training, and other supporting services. We are an official member of Enterprise Europe Network that allows us to contact with different business support organizations in Europe, such as Istanbul Chamber of Industry. And we actually partner with different government agencies and business support organizations, both in China and in Europe, in order to reach to our target audience, which are those SMEs looking into entering the Chinese market. We have an office in Beijing and once in Brussels, thanks to one of our implementing partners. And actually here you can see the organizations who are behind the EU SME Centre project, being the Cámara de Comercio Italiana in China, the leading partner. In terms of services, we offer 4 main blocks of services. The first one is the Knowledge Center. I usually call it an online library because here you can find over 200 market reports, case studies, guidelines, and business articles on different China-related topics. Some of them are very transversal, such as e-commerce, digital marketing, or HR-related issues, but some others are more focused into specific sectors. And here you can find market reports focused on environment and green tech, food and beverage, or for instance, the healthcare sector. All of you can actually are able to download these market reports. You only have to register on our website, which is totally free. Oh, yes. Indeed, which is totally free. And thanks to this registration, you will be able to access to the market reports, but also to the rest of the services that I'm going to be introducing right now. The second block is the Advice Center. Here we provide one-to-one consultation support to our clients, or our members. Here you can ask any question you have related to business development in China. It could be related to, for instance, HS code regulations, import duties, or any market restrictions that there might be implemented in China. I would like to introduce you a new service that we launched at the beginning of this year. It is called the Self-Diagnosis Tool. This is actually an online system that allows companies to gauge the level of readiness towards the Chinese market. There is a general assessment or a general quiz, which usually takes 10 minutes, and 4 specific ones focused on business environment, product, funding, and HR that are more specific into these areas, which are extremely important for companies considering entering the Chinese market. The most important thing is that apart from allowing you to assess your level of readiness at the moment, the system also includes some learnings and recommendations to help you better prepare or be more ready towards the market. The third block is the training center, and today is a great example of what we are doing in this section. We try to plug the knowledge and skill gaps of SMEs trying to enter the Chinese market. I recommend you to look or to visit our calendar section on our website to see the trainings that we are organizing. Perhaps, if I'm not wrong, you can see right now activities organized until November, but we continue adding more events and conferences on daily basis. So stay tuned also through our social media to not to miss any opportunity in this regard. And last but not least, we also have an advocacy platform that actually helps SMEs to be up to date on information regarding the regulatory market and any economic and social changes happening in China. Here we also try to give voice to the concerns and requests of the European SMEs that are operating or intend to operate in the Chinese market. A little bit of a picnic of what we are going to be doing in the coming weeks. Here I would like to remark that we are organizing a European pavilion in the upcoming China International Industry Fair, where quite a lot European businesses are going to be promoting their products and services. If you happen to be in Shanghai or in China, we will be happy to welcome to this pavilion where some side sessions, conferences, and activities will take place. But also I would like to mention that on the 21st of September, we are organizing an event focused on startup funding and entry into the Chinese market. You are very much welcome to join any of these events. One last opportunity I would like to share with you today is that we have launched a call for proposals for successful stories of SMEs selling into China during the COVID. Here we are looking for companies that have been able to navigate or to start selling into China during the COVID by implementing a business transformation. It could be related to digitalization, product innovation, implementation of a new technology, but also changing the different distribution channels or the sourcing markets. Any interested company that think that could be a good fit for us, we are still open for one last candidate, and you can send an email to me, laura.velasco@eusmecenter.org.cn. We are going to be distributing the slides after the event. We will send you a link that will allow you to download the presentation, so you will also have access to this email address. And last but not least, before we leave the floor to Daniel, just one technical reminder. We are quite a lot of people today, so I would like to kindly ask you to submit all your questions through the Q&A button, and we will leave the chat just for greetings and comments so that we can all be able to trace your questions and organize the answers in the Q&A session. Daniel is going to be answering as many questions as possible in the Q&A, but we encourage you to submit the questions along the session so that you don't forget them, first, and secondly, because this will allow us to seize how many questions we have and to organize the time in an efficient way. And now is the time for Daniel. Daniel is a senior legal counsel and head of the Spanish and Latin America desk at HFG Law, which is a law firm focused on intellectual property in China. His fields of expertise as such are obviously intellectual property rights, privacy, data protection, and corporate affairs in China. Daniel is a frequent speaker at conferences and seminars on China corporate law, and this is actually how we met Daniel. And here I'm including his contact details in case you want to reach out to him. And now I just want to thank everybody. Remind you that at the end of the event, when you exit, you will have the option to answer a feedback survey, a questionnaire, and we would like to encourage you to take those 5 minutes just to give us your feedback and to let us know about what other China-related topics you would like to learn. Thank you very much again. And Daniel, the floor is yours.
Thank you, Laura. Thank you also to Suleiman. Well, I would like to start thanking the EU SME Centre for organizing this webinar together with the Istanbul Chamber of Industry, and also for giving me the opportunity to be here today and speak about sales contracts in China. Which is today's topic. I'm gonna share my presentation already. I hope you had a chance to have a good cup of coffee already, because it will be a long presentation, but I hope it will be interesting for you as well as especially useful for the future, for any purpose, for any event or project you may have ahead. For developing your business in China, and if you get involved into negotiation of a sale contract in China, I hope I can give you some tips today, and you can have some clear examples of what to do, what not to do, and how to follow, how to proceed with negotiation with Chinese partners, and how to draft a good and especially a safe sale agreement in China. Well, let me just introduce the law firm that I work for in China. HFG is a Chinese law firm. We provide legal services in mainly three areas, specialized in three areas, which are corporate law, like Laura already mentioned, Also, we have a great specialization in food law, with a specific department that we work with many food companies, develop their business in China and export their products to China. And also the core, I would say, yes, the core of our legal services are intellectual property as well, where we have a very good specialization with very good professionals in China as well. Like I said, we are a Chinese firm, local firm, but we with offices in Shanghai, Beijing, and Tianjin. But we mostly provide services, legal services for international companies who want to develop their business in China, from corporate affairs like setting up companies in China, negotiation of contracts, of course, and then, like I said, food law and intellectual property. We are around 90 professionals within the firm, mostly obviously lawyers and also trademark and patent attorneys. Well, we assist, like I said, many multinational companies, but also we are very focused on the small, medium enterprises, as we know are the core of many countries. And we try to help them to develop their business in China as in the safest way as possible, and provide good tips and good legal services to help them to be successful in their projects in China. So we'll not delay more today's topic, so I will get into business now. I always like to start my presentations when we have a webinar about China for foreign attendees mostly. Well, putting things a little bit into context when we talk about China, because China is nowadays one of, well, it's in everyday's news for many reasons and with regards to many different aspects. But my perception and the perception that many foreigners that work in China is that China remains very or greatly unknown for most of foreigners, and especially Westerners, because in Asia it's different, the feeling. But for Westerners, we believe China remains very unknown. Chinese culture, Chinese tradition, Chinese mindset, and in the practice when we talk about business. It is very different, and I always like to start any lecture or any presentation like this one with well, 2 paragraphs taken from a book that a colleague of mine used to work for the firm, Nicola Porti, wrote in a book about food law in China. And he said that the main mistake, and unfortunately also the most common made by companies when they start the development of a business project in China, is to underestimate the enormous differences between our countries or other emerging countries and China. We need to be aware that China is different, a world apart, and in many ways featured by unparalleled complexity and unique distinctive peculiarities. So now, more than ever, there is no room for improvisation in this market. And it is our perception, and we see it on every day, so on a daily basis. It's not understanding this or not taking into account the means losing the battle before having any. Okay, all right. I'll try to keep my side on the screen. So, like I said, well. Not account this means losing the battle beforehand in any project that we start in this country. So I just wanted to point out this because we see it's crucial. It's very important that we keep it in mind when if we are assessing, if we are intending to develop a new project in China and getting into business in China. And to try to put some examples, graphic example of this, we know that for many companies, they believe, they think China may be a gem in terms of business, but what they don't realize many times is that it can also be kind of a jungle where you will have to defend your product and your rights. And this slide that can be a little bit fun, it is not all fun if we put it in the right context, as unfortunately we have seen in the past, in the last year, due to the pandemic, due to the situation we all are going through, where we saw many, especially European governments that went to China to purchase medical devices or face masks, and they got involved in very bad business. They had so many legal issues purchasing all these products in China, and it was mainly because they didn't get the right advice when they tried to develop these or to purchase this product in China. And we are talking about national governments or regional governments within China, European countries. So obviously the situation was well, of extraordinary nature. But even though this is an example that we need to be aware of the differences, and we need to prepare in advance and to be aware for well, having all things that we will comment in the presentation today when we start the development of this. So I will not. Well, I just wanted to put this in context because we believe it is very important for you to keep in mind when trying to get into business in China, especially when dealing with Chinese partners. So I will just jump into today's topic, which is drafting sales contract when exported to China. In today's agenda, we have well, different points, and just to let you know that the last point there, which is a case study, I will not well, I will not leave it for the end. I will just, during my presentation, comment and speak about real examples of contracts. You will see examples of clauses and provisions that we have included in contracts for clients, so you can have a good understanding of what I'm talking about, and you can see real and practical examples of the most common issues, legal issues and problems that foreign companies face when developing their business in China. So let's start from the beginning. Pre-contract stage. We are let's always put. I'll put myself in the position of a foreign company. It can be Turkish, or as a whole European, or it can be a South American or North American company. Let's say foreign company developing business in China, or I'm interested in. I found a potential partner in China, and I want to start well, talking with them to see the expectation we have to develop a business in China, in which I want to sell them some products that I produce, and I want them to be exported to China. So I found this partner, and it is essential at this pre-contract stage. So initiating the negotiations or the talking with the Chinese partner is to check the status of this potential business partner. How to verify the legal status of a company? Well, it is. I say this because it is something that this step is not usually conducted in Europe when doing business in Europe or in North America or in South America, I believe. It is different in China, like I said, and I'm gonna remark this all the time because in China we've seen, unfortunately, examples of foreign companies doing business with Chinese partners that in the end turned out not to have a company, or the company that they say they had was fake, or the name was fake, or there was some bad issues or legal issues with regard to the nature and to the status of the company that the foreign company was intended to develop the business. So how can we make sure that our business partner in China is reliable? Well, nowadays, corporate information regarding Chinese companies is available to everyone, actually, to any third company by public and private sources. So it's quite easy, actually, and we can just well, conduct simple searches on databases, on public and private databases in China, where we can easily obtain relevant information about our potential business partner. So we can assess its existence, and I say existence because we've seen cases in where there was not a company, even though they use the name of a company, obviously. We can check the status and nature of the company, whether or not they have been involved in previous civil or criminal disputes, or we can also check the company registration information, registered capital, the address, the identity of the legal representative for the directors, etc., etc. And all this information can be a good insight and can be very useful for us to confirm that our business partner can be at least in principle reliable, and we can get through negotiations, we can start the business in the safest way possible. This is just an example of these public databases that you can see here. This is all the information that is available from public sources. Unfortunately, this information is only Chinese. It's only available in Chinese, but it can be also translated into English, like we have done here in this report. This is an example of a report we usually provide for clients about a Chinese company, where we provide mostly corporate information about this company. This is another example. This is just from a private source platform. Available to any third party. This is a subscribing platform anyway, but all the information can be obtained as well. And in this case, we can conduct also a deeper search to check whether, like I said, whether our potential business partner has been involved in previous litigations, for example, and what was the cause or the object of those litigations, which will give us a good impression or a good insight about the reliability of the business partner. Moreover, I also would like to stress that if the sale contract we are entering into is of a special relevancy, we highly suggest to obtain a credit or financial report about the potential partner. So this way, we may also assess the financial status of the Chinese company and the financial capacity to pay us in case we go through the contract and we enter into the business. So this said, now we also I will comment the second part of the pre-contract stage. So once we know a little bit more about we know the background of our potential business partner, we should focus as well on what irregularities we should pay attention to about the activities our potential business partner has been conducted. Once we know the field of activity, or we know the kind of products we are selling, for example, it is of special relevancy to check unqualified operations by our potential business partner. What is the meaning of this? The business partner needs, in many fields in China, they need to have specific qualifications or have obtained specific permits to develop their activities in China to be able to sell products in a legal way, let's say. So they need to operate with specific products or within a particular field, and it would be advisable to ask them to provide, to confirm that they have those licenses in advance, and if so, just include the draft and that wording in the contract, so they guarantee that they obtain all the required qualifications to sell the product in China. Just to give you an example, if we are negotiating the sale of food product, the Chinese company must possess certain specific business license, and this is, like I said, this can be easily checked and confirmed, but it is advisable to do it in advance into the contract. Furthermore, yes, we should avoid cooperating. It is obvious, it sounds obvious, but we've seen examples of that. It was not the case. We should avoid cooperating with companies whose qualifications are about to expire or have expired, because we saw this in the past, like I said, and we faced a situation in which a client enter into a contract with a Chinese partner who had no qualification to sell the product in China, and still he was selling the products in the market. So another check that we can conduct is that the company is not included in a blacklist in China, which is something that they can be easily checked as well. This blacklist normally is formed by enterprises who has been involved in regular activities or acts, and then the Chinese authorities include them in the blacklist. So we can check this in advance as well, and at least have another input about the reliability of our partner. And finally, like I said before, litigations. We can check whether or not our business partner has been involved in previous litigations, and what was the cause of the object of those litigations, at least to dismiss Okay. Okay. Well, I cannot do anything about the internet connection, but I'll try to focus on the screen. Like I said, well, just to give you an example of an actual case, the client was contacted by a company in Xi'an. This was a previous case that we assisted the client, in which he was about to enter into a contract with a Chinese partner. Well, we told them, we advised them, okay, ask your business partner to provide his business license. The business license is just well, the authorization, let's say, the certification provided by Chinese authorities to a company, like to confirm that a company is duly incorporated in China and has all the qualifications. So this Chinese company provided, submitted this business license. And after we verified the information, we found out that the company had been liquidated, had been dissolved 1 year before. So the client was about to enter into a contract with a Chinese company that didn't exist in the end. So this is just an example of how important it is to conduct these pre-checks or preliminary checks that can help us to to assess the reliability of our business partner. So just let me get a sip of water. So I will move forward with today's agenda. So I will get into point B, or point 2 in the agenda, which is properly drafting a contract with a Chinese company. Which points we should take into account and we should consider to make a contract not only valid, but also obviously safe and enforceable in case we see ourselves in a legal issue or in a case of breach of any party's obligations, and we need to enforce the rights and the contract and defend your interests or your rights in China. So I will follow these 4 points, make it valid. Then we talk a little bit about payment methods and terms, important provisions that should be or must be included in the contract. And then we will talk a little bit about contract negotiations. So more from a cultural perspective, how to face a negotiation with a Chinese partner. So I'll start just giving you a few tips about key formalities of Chinese contractual practice. So what kind of things we should take into account, what particularities we should consider that are actually quite different compared to the European practice or the US practice when we talk about contracts. These particularities of China contractual practice and legal system must be duly considered when entering into a contract or before entering into a contract with a Chinese company. Keep that in mind, will allow us to protect and secure the validity and enforceability of the contract, like I said. So what are we talking about here? The CHOP. This is sometimes many times, unfortunately, completely unknown for foreign companies doing business in China, or at least in the beginning before they start doing business in China. A contract, when in the European practice, a contract is usually binding when it has the signature of the legal representative or the representative of the company who has the capacity to represent the company for that act. In the case of China, in Chinese practice, this is completely different. The contract must be chopped with the official corporate chop of the Chinese entity, of the Chinese company. You can see here an example of the chop, how official corporate chop in China looks like. And this is really what is binding for Chinese companies. So when we are about to enter into a contract, the European or the Turkish or the American party can just sign the contract and that will be binding for the other party. But in the case of a Chinese company, we have to ask the Chinese representative to chop their contract with the Chinese official or the official corporate chop, because it will make the contract binding for both parties. And it is very important we keep that in mind. Otherwise, we can see ourselves in situations in which the contract may not be valid. So this is crucial for the validity of the contract, and it is a formality that we need. It is essential. It is crucial to keep it in mind. So in addition to that, we often see Chinese companies using English names when doing business with international companies. And we must be aware that it is essential to the Chinese name of the Chinese company in the contract, which is not always there, as we have seen many cases of clients that we assisted. English names of Chinese companies are not official, and they tend to be made up. They are not official. They just use it for the sake of clarity many times in the negotiation. But when we are about to enter into the contract, it is essential that we ask our business partner to provide the Chinese name of his company, and that should be drafted and that should be included in the contract. Sorry, because I was checking the video.
Daniel, yes, just a brief thing. I turn off your video just to ensure the quality of the audio. Okay, but I didn't want to interrupt you. Sorry for that.
That's totally fine. I just realized now. Is it better now, the audio?
So far it seems good. We will let you know if it gets a little bit poorer.
Okay, sorry about that.
Thank you.
About the original version of I just mentioned the Chinese name of the company, but about the original version, it is also essential and very important that we always obtain and keep an original version of the contract duly signed, like I said, and chopped by both parties. If we are in a situation of a breach of the contract and we need to go to court to enforce the agreement, Chinese courts will not accept scanned versions of the contracts. We need to have the original chopped by the Chinese party. So it is important that we keep that in mind. So also bilingual agreement, it is highly advised to obtain the bilingual agreement and avoid further misunderstanding and rush with translation in case of issues. So I will move now to the second point, payment negotiation on term. I will just mention now the most common payment methods used in China. And later we will see a little bit more about how to draft a clause or a payment clause in the contract. So where are the most common payment methods used in China? Well, first one I would say is payment upon shipping documents. So in this case, we can just we will analyze these and you can take it into account. You can remember that when negotiating a contract with a Chinese partner. So in payment upon shipping documents, the buyer shall be liable for payment when the seller delivers the relevant shipping documents in accordance with the contract. And in this case, the seller will only submit the title of ownership, which will represent the transmission of the goods to the buyer upon payment, which is the safer way for the seller, obviously. So if we are the seller, we may use this method and it will be safer for us. Obviously, this will be subject as usual to negotiation with the counterparty, but it's for you to take it down. Second one is payment by installments. This one is one of the most used methods when conducting business in China, or at least for international trade, especially for the sale of large equipment products. Generally, in this case, the seller will require the buyer to make a down payment when confirming the PO or enter into a sale contract. I mentioned now the PO, the purchase order, because as we will see later, sometimes if the sales of products are gonna be conducted or carried out on a permanent basis, we will have a sale agreement that will act as a master agreement, and then each sale will be regulated as well by a purchase order to make it simple. So in this case, normally once we have conducted this down payment, and the remaining amount will be paid in one or several installments according to the contract at different stages. The last payment is usually paid off upon delivery of the products. But for instance, we can have an upfront payment of 25% of the total amount in the beginning when we enter into the contract, for example, and then the remaining 75% of the total amount can be paid upon delivery of the products, or we can do more installments if that is safer, or we can agree on those terms with the counterparty, and that can be the parties can feel more comfortable doing it this way. The options are many in this case, but just for you to know that you can, and Finnish companies are very used to this method. The third one is payment upon collection. So in this case, the seller will issue a bill of exchange with the buyer, as the buyer will entrust the bank of the seller to collect the payment from the buyer through its branch or agent bank. Make sure the payment takes place. The fourth one will be a payment upon delivery. In this case, the buyer shall be liable for payment when the seller delivers the goods at the designated place. In this case, we need to be aware what delivery means, and that will be regulated in the contract. We will talk about it later. And also, if we include an Incoterm, we can also keep that into account, as the Incoterm will clearly regulate when the delivery, so the transmission of the goods and the risks will take place. And last one, which is the payment upon letter of credit, which is also a very common method used in China. And under a letter of credit, the payment for goods is conditional on obtaining the shipping documents according to the provisions of the letter of contract, which will help us to avoid the risk of prepayment or the upfront payment, like we said before. So the greatest benefit of the letter of credit is to appoint a reliable payer, which is the bank. And the benefit for the buyer is that the buyer does not need to pay until the goods are shipped. The letter of credit is usually very common, as it provides guarantees of payment for the seller, but also allows the buyer not to pay until the products are shipped. So this can be more safe for us as sellers as well. And also can, as we have a bank in the middle, placed in the middle of this, it can also provide guarantees of payment to us, and will help us to feel more comfortable and reduce the risk of non-payment. So just let me mention here that bank guarantees are not common in Chinese commercial and contractual practice. So we should not expect our business partner to accept this option. I like to mention this because I know this is quite common in European practice sometimes, especially for contracts with larger scale contract. So just for you to know, and that you should not expect this practice with your Chinese partner. So let's move on today's agenda with the third point, which is purely and properly the important, the relevant provisions that should be included in a contract, in a sales contract when negotiating with a Chinese partner. I'll make initially a general approach, and then I'll move on with the just talking about each most relevant provision that should be included in the contract. Obviously, I will not comment all of them, all the provisions that are drafted included in a contract, but at least I'd like to mention those that are more characteristics of a sales agreement, and can help us to regulate those provisions in the contract that can help us to have a safer conducting or performance of the contract. So I will, like I said, initiate this part with an overall approach of what to take into account when we talk about contracts in China. This is very important it's very important to remember these tips when you are about to draft or to get into the negotiation of a sales agreement in China, because we should focus in China on the basics and eliminate unnecessary details. Take as a rule these 3 words: simple, clear, and precise. The contract must be simple, the contract must be clear, and must be precise. We should avoid standard common law agreements and use simple and straight contracts. Complete, of course, but precise and clear contracts. If we use common law agreements of 50 pages where I have nothing against these agreements. It's just they are not that effective in China. They are very good from a technical point of view, but Chinese like very short and precise and simple agreements. So we should try to focus on those points and include or all provisions that must be there. That should be non-negotiable, of course, but remember this: simple, clear, and precise, and that will help us also with the negotiation of the agreement. When otherwise, if we raise or we send to our counterparty, to our Chinese partner, 50 pages agreement, they will get crazy, and they are not used to that. They don't like it, and many times, unless we are working with multinational Chinese companies, which in that case it should be different because they are more used to international practice. But in the case of small, medium companies in China, these rules should be kept in mind. So, like I said, simple, clear, precise, state and lawful obligations: who shall do what, when, how much, how many. So the basics, like I said, sorry to repeat myself so much, but this is important. Penalties for breach should be included, even though it might be subject to moderation by the court in case of breach of the agreement. Clear deadlines and way out termination clauses. So especially for the termination clauses, if we are initiating, if we already know our business partner is different, but if we are before or about to initiate our business in China, I always suggest and recommend for you to include short term of the agreement and also draft a termination clause in which the contract can be just terminated by both parties without any penalty, because it will help us with the development of the business in case it doesn't work or it is not working. And once we know our counterparty, once we have set it, our operations, it may be different, and we can have a more complex agreement, or we can have a longer contract. But in the beginning, I advise you to be careful and initiate the operations with a short-term agreement. Important provisions. Well, I'll start with the first one. Is product description clause, and here I would like to make a difference. That in those cases that we are in front of a one-off sale contract, or just it is a sale contract that regulates sales on a permanent basis or upon request of the buyer. We should make this different. You will see why now. So the description to be included in the contract must take into account the frequency of the sales and the scenario in which the parties will perform their obligations. Like I said, it is not the same one-off sale agreement that an agreement that will include sale of the products in different batches. The product description clause in a sale contract for a one-off sales, for example, is this one that you can see here, where we can see that very clearly specified the product specifications, the quantity, the unit price, and the total price. And it is very simple, but it is effective. And it is what it counts here. So if like I said before, the sales contract, or we are in the scenario of a sales contract in which sales are performed on a permanent basis. Then the regulations should be a little bit more complex, or at least a little bit more complete. So we can say this two that you can see here are real examples of clauses included in contracts that we have drafted for clients. So for example, the product sold by the seller and bought by the buyer will be specified in the sale order, because now, like I said before, in this case, the sale contract will act as a master agreement. So we don't have to modify every time that we conduct a new sale of products. We don't have to modify the agreement. We don't have to repeat and to create a new agreement, and we enter into a new agreement. We just regulate this in the sales agreement, and then each sale for new products will be regulated by a sale order or a purchase order, in where we the relevant information. It will be short and easy for the parties to do it this way. So I advise you to understand in which case we are when negotiating with your business partner, and adjust the drafting and the wording of the clause in this regard. So in the second case, for example, it is different. We see a sale contract where sales takes place upon request of the buyer. And we said in this case that you can see in the example, we see that the products sold by the seller are disposable medical devices. And as the seller has a very wide range of products, including several hundreds of SKUs, a complete catalog or list of products does not exist. And then pursuant to the purchasing process described in Article 2 of this agreement that we will see later, on a time-to-time basis, the seller will confirm to the buyer the availability of the specific product requested by the buyer and the conditions of its sales. Simple. And so the seller, the buyer will contact the seller for each time that they want to conduct a new purchase, and just sending a purchase order that will be regulated in the contract. So this Article 2, like I mentioned before, the purchasing process provision. So this is a new clause, and in this case, it is essential to include a detailed description of how the product shall be ordered, and when such order will be considered as accepted by the seller. So this is important to avoid any further issues later, when maybe the buyer is interested to buy some products, but in the end, he changes his mind, but maybe the products have already been produced, and we see ourselves in an awkward situation. So to avoid that, it is important that we regulate in the contract, we include in the contract how the purchasing process will be or should be carried out. For example, in a one-off sale, this will not represent much trouble, as we will just describe above details. Obviously, if there's only one sale, we will just include it in the contract and draft it in the contract. However, if the sales are expected to be performed on a permanent basis or from time to time, then a clear description of the process is highly advised to be regulated. How this purchasing process will be conducted in the following way, and I think it is important for you to keep it in mind. So I will read this clause. So in this article, we will specifically mention that the supply of the products will be performed in several batches. So we are clear about the scenario, and the purchases process between the parties will be carried out according to the following provisions and by means of a specific purchase order. Every time the buyer wants to receive a new batch of products from the seller, the buyer will communicate with the seller to let him know the basic information about the supply. The communication and information referred to in point 2 will also be provided to the seller by means of a purchase order, whose template is attached here to as Annex 1. Well, this is not essential, obviously, to include an example or a template of the purchase order, but it will ease the performance of the contract. It will ease the operations, and especially it will reduce the risk of not having all the information that we need and we may need if there's any legal issue later in the contract. If we include just a simple template we attach it to the contract, and that simple template of the purchase order is what the client or the parties will use during the performance of the contract to request new purchase of products. So the purchase order will specify all the information described in this template to formalize and execute the purchase. And then this is the clear proceeding to avoid misunderstanding later. So within 5 working days from receiving the PO, if the seller accepts the PO, it's all sent to the buyer with confirmation, which will be the confirmation, and then the order will be considered accepted. If the seller does not accept the PO, it's also sent a request for modification to the buyer, which can be accepted or rejected by the buyer. If rejected by the buyer, then the seller and the buyer will have to negotiate to agree on the final terms for that PO. This may sound a little bit complex now, but believe me, it is very simple once you are used to it, and it will really ease the performance of the contract and the operations later if you do it this way, and especially will reduce or greatly reduce the risk we can face in case of breach by our Chinese counterpart. So if the seller within 5 working days from receiving the proposal sends neither the confirmation nor the modification request, it shall be deemed that the proposal has been rejected and therefore the supply has not been concluded. And it is important that we state this in the contract just to clarify that, okay, no confirmation from the buyer, then I have not accepted, I will not produce, and I will not accept any claim from my partner in that regard. So for the avoidance of doubt, to end the clause, supply of the product shall be deemed agreed with the parties only when the confirmation sent by one party to the other party matches the last PO or modification requested by the other party. That agreed PO shall be deemed as the confirmed PO. In this way, if we don't have, like I said, if we don't have that, we prevent any issue from later or in the future from or complaint from our counterparty in this regard. I move forward to the next slide, to the next provision, which is payment terms. We have seen the payment methods available in China, or most common in China, and now we will just see an example of those how to draft that clause and what to include, what is the wording or the recommended wording to be included in the payment terms. Well, it is essential, especially to clarify that all payments due to the seller are paid net and without deduction of taxes, customs, duties, or other charges of any nature whatsoever, so we prevent any dispute over additional cost. And this may seem obvious, but it is not that obvious when, and we have seen it in many cases where there's a dispute over the amount that was paid in the end to the seller, because the complaint or the Chinese partner, which is the buyer, will claim that it was the seller who had to be charged with the payment of specific taxes or customs duties or other charges. So it is important that we clarify this in the contract, and it is clearly regulated. And in the event of partial or total breach by the buyer of its payment obligation, we should grant the seller the faculty to suspend the performance of its obligations in the contract, including but not limited to the delivery of the products until the buyer fully complies with its payment obligations. So this is just grant the seller the option to say, okay, I have not received payment from the buyer of the first installment, for example, so I will suspend my duty to deliver the product, because until I don't receive it, I don't have to come to receive the payment. I mean, I don't have to deliver the products. And if we don't include this, if we don't regulate this option, this faculty for the seller, you may be or you may be in the position where we have to comply with the contract, even if you have not received the payment and deliver the products anyway. So it is important that this is clearly regulated in the contract. We can also set out penalties to the buyer for late payment as a coercive method to push the buyer to comply on time with his obligations. For instance, just to give you an example of one of these clauses, and in point 3, this article, in the event the buyer does not perform with its payment obligation pursuant to the article 3 point above and the confirmed order, late payment penalties should also apply of a rate of 1% over the total price of the unpaid confirmed order per day. So this is, like we said, is a penalty for breach of the contract, and this can sometimes work to push our counterparty, our partner, to conduct the payments on a duly and timely manner. Moving to the next clause or provision, which is the delivery clause, in which the description of how the delivery will be carried out, delivery of the products that we are selling to our Chinese partner. Process, periods, and liabilities should be clearly described, with a special mention to the transmission of risk and use of Incoterms. In a one-off sale, we will specify the term agreed for the delivery of the products as well as the Incoterm, if we have agreed with our partner to include an Incoterm, which will govern the allocation of responsibilities in case of any loss, damage, or breach of the conditions agreed. If we don't include any Incoterm, then it is okay, but we will have to include a more extended regulation of liabilities in the contract. So I highly suggest to include the Incoterms because they are very clear and they help for the parties to understand what are the obligations and how to face and how to assume them. So in a scenario of a sales contract for sales to be performed on a permanent basis, we may consider the following provisions to regulate the delivery of the products to our Chinese partner. So the seller shall deliver the products to the buyer or to the importer, as the case may be, within the delivery term and in the manner specified in the confirmed order. This is very important. This is crucial when I say buyer or to the importer, as the case may be. And it is not by chance that we have included in the provision here in the wording, because we see many times in Chinese practice that Chinese partners tend to use one company to enter into a contract, but then you a subsidiary or a third company to perform the operations regulated by the contracts. And by operations, I mean, for example, the acceptance of the delivery of the products. So the entity or the company who receives the products in China that we as a seller I am sending to them is different, and that can be very problematic for the liabilities in the contract, and for me as a seller to prove if there is any problem that I duly submitted the products on time to the right party in the contract, because if it is another party, it may be a problem. So just for you to know the importance of this. So, and before we enter into the contract, before we execute the contract, we should clarify with our business partner in China whether or not they will use the same company to accept or receive the products. And if not, if the importer will be another company, then it is important that we clarify, we regulate that in the agreement, and we specify which company will be. If possible, we will include it as a party in the agreement as well, just for the purpose of importation of the products, for example. But it is very important that we set out that regulation, and we mention that in the contract, so we don't have further issues later on. So just to continue with the clause, then we describe how the delivery will be processed or carried out. So all products ordered by the buyer shall be packed for shipment in accordance with seller's standard commercial practice. This is just with regards to the packaging requirement. So it should be the buyer's obligation to notify the seller in any special packaging requirement, and any packaging modification different to the standard commercial practice of the seller shall be made at buyer's expense and subject to the seller's approval. We specifically state this in the agreement because we've seen many cases in practice where there was a lot of complaints of the Chinese partner about the packaging when receiving the products, and actually it was kind of these cases the Chinese company was taking advantage, or we saw they were taking advantage that they didn't comply with other obligations, so they used this to claim that the goods didn't comply with their requirements or requested by them. So if we include this wording here in the clause, we make sure that if any packaging requirement, then it should be specifically requested by the buyer. Otherwise, we comply with our other obligations and we use a standard packaging requirements. So, notwithstanding next paragraph, notwithstanding with Article 4.2 above, the seller will use its best efforts to assure that the products are delivered for shipment in perfect conditions for its use, and the products will be delivered to the buyer on a timely basis insofar consistent with the confirmed order. However, seller makes no representation or warranty regarding timely delivery or quality of the products other than those expressly contained in Article 7 herein below. This is just for you to keep in mind, and this specifically a statement about no representation or warranties by the seller. It is not always, so this is subject to negotiation, obviously. And if I am the buyer, if I am the counterparty, I will not accept the seller saying that he will use its best efforts. I want them to guarantee that he will conduct the delivery on a timely and duly manner on the terms agreed. So, like I said, it will be subject to negotiation for you to know this, but if you can obviously obtain a more favorable wording and agree that with the partner, it will allow you to reduce the risk you can face in case of breach of the timing set out for delivery. Well, just to end up with this clause, say that the parties agree that the applicable Incoterm that will regulate the delivery of the products pursuant to this agreement shall be CIF. In this case, it can be any of them. Whatever you negotiate, this is up to pure negotiation, and it is just a way to simplify the agreement. Just to end up, for the avoidance of doubt, it is the buyer or the importer obligation, as the case may be, to verify beforehand full compliance of the product. This is important with the People's Republic of China applicable laws and regulations. So in the event of any issue for the importation and sale of the products in China, due to no compliance of the products with the applicable laws, the buyer or the importer may be, so have no cause to raise any claim against the seller. So it is crucial that we specify here, so with the risk of making sure that the buyer not only have obtained all the qualifications, and like we said in the beginning, to sell in a duly manner the products in the Chinese market, but also that those products comply with all applicable laws in China, and that is up to the seller risk and action. So it is a way to eliminate the risk for the seller in this case, so the buyer cannot raise any claim later in this regard. Okay, so next clause, next one is obligation of inspection upon delivery. Sorry, a sip of water that you cannot see me now, but so obligation of inspection upon delivery. This is also not usually kept in mind, not considered in many contracts. But it is essential to avoid, because we've seen many complaints raised by Chinese partners, especially later. I give you an example here in the presentation that including the quality standard control procedures clause will allow us to not only to state that, but also to prevent further legal issues in the future when performing our obligations in the contract. So by regulating a quality control procedure, we will prevent our business partner to raise ungrounded complaints over the quality of the products delivered, or even use such argument as a countermeasure in a dispute over a potential breach of the buyer. This is the example I give you here, and it is an example based on our previous experience in many cases, like I say. In which the buyer fails to pay the agreed fees within the stipulated term, and then upon the complaint of the seller, so the seller raised a complaint saying, hey, you have not complied with your obligation of payment as stated in the agreement, and then the buyer claims that the product received had malfunctions or did not comply with the requested features. This is very common, and a way to prevent these situations, these scenarios from happening, is to include in the contract clear provisions of inspection upon delivery of the products. I have included, as you can see here, an example of the drafting of the wording we usually include for this kind of provisions, in which we say that upon delivery to the buyer or the importer, I repeat the same situation, pursuant to Article 4 that we have seen before, the products shall be checked. This is upon delivery. The products shall be checked and tested by the buyer or the importer. For the avoidance of doubt, the buyer or importer shall organize the inspection at the place of delivery, which will be defined in the order. If we are in front of, or we are working with one-off sale, then rather than in the contract order, we will specify all those details here in the contract. In the event that, I continue with the clause, in the event that upon this inspection, any damage or defect is detected on the products, the buyer or the importer shall communicate it to the seller as provided by Article 7, that we'll see later. If within 3 days upon delivery of the products to the buyer or the importer, they do not raise any writing complaint concerning the quality or quantity of the products, as well as any other condition specified in the confirmed order that the seller had to meet, the products delivered should be in fully compliance with the provisions of these agreements and the confirmed order. And that means that there's no way later the seller, the buyer will be able to use these in case they don't comply with their obligations. It is clear that if they don't raise any complaint in this 3 days period, then the deadline has expired from them to raise any complaint in this regard. To continue with this, just to mention that in the event that within the period of 3 days upon delivery, pursuant to Article 4 and 5, the buyer or the importer raises in writing complaints, so we have seen the case in which there is no complaints from the seller about the quality or the quantity of the products, and now we regulate, we state what happens in case there's any complaint, which may be usual in some cases, about the quality or the quantity of the product. And in these cases, the complaints must be done in writing, and one person appointed, in this case by the seller, and one person appointed by the buyer shall jointly inspect the products and verify the reason of the complaint. If after such joint inspection, the parties agree that some or all the products are proven to be not compliant with the conditions specified within the agreement or the confirmed order, the seller shall provide new products in substitution of the non-compliant or damaged one. This is the sole and exclusive remedy provided by the seller for any breach of seller's warranty under this agreement. This last sentence is important. It's important for you to keep in mind, because we are limiting our responsibility, our liability, in case there is any malfunction or any quality issue with the products. So in that case, our sole remedy will be limited to provide or substitute the defective goods again to the buyer. And finally, I believe this is this is not the last one, but almost. Important provision that should be regulated in the contract. I'd like to mention the intellectual property clause, especially for what this represents in China nowadays, the problem that many companies, many foreign companies are having about, especially related to trademarks and to the, not only to the use of trademarks in China, but mostly about the registration of their trademarks in China, and the issues they are encountering when trying to develop the market because of this, because they are not able to register the trademark in China. So what should I do? Besides the drafting of the agreement, what should I do if I am about to enter into a business in China? I am considering to sell some products to my Chinese partner that I already met and we found an agreement. Even before of that, as soon as possible, I need to check or I need to wonder, how will I commercialize my products in China? So what will be the distinct side that I will use in the packaging, for example, not only the trademark, but also if my packaging is very distinctive for any reason, those distinctive signs can be also be protected. And it is very important that I do it, because if I don't do it, there will be a third party in China that will do it, because they will see the importance of that in terms of marketing the products. So this is like this would be that's the first step. So anticipate to the situation and wonder about these questions. And the second steps is just to conduct the registration of the trademark. But for that, before you do that, you should also wonder whether you have previously checked the status of those distinctive signs on your brand in China. This is important because in many cases, and you will see, and you can try. You can check whether you have your trademark registered in China, and if you have not done it and are considering to develop your business in China, you may see the situation in which you will find that probably a Chinese company have already registered your trademark if they have seen that it is successful. This is unfortunately very common. It is getting better and better thanks to the the work of the Chinese authorities of the Intellectual Property Office, but it's still in practice, we see many Chinese companies registering in China the trademarks of foreign companies. So taking that into account, ideally, you should conduct a search for your trademark in China to detect or find out potential similarities on the same sort of products. So check whether your trademark may have already been registered in China by a third party. If not, register a trademark, design, or any IP right you own even before you decide to expand your business to China. So even if China is only the country where you produce or manufacture the products, it is still highly advisable to protect your IP rights there. Like I say, you may not believe it, but your trademark is likely to be already registered in China. So it is important you keep that in mind, you check it and take actions as soon as possible. You may not believe how many business or potential business still have been frustrated because the foreign party was not able to commercialize their products in China using their own trademark because of intellectual property issues, because of these situations that we just mentioned. So this is crucial. It is much more important than many times foreign companies considering China. So we strongly advise you to check that and to take action as soon as possible. I have included here the drafting of an intellectual property clause to be included in the contract. I will not read everything now because it is long. I don't want bore you anymore, and this is already quite long. You will have the presentation available, so this is for you also to review it, to go through it with more time. If you have any question, obviously you may ask me now in the Q&A section or later by email. Feel absolutely free to send me an email with any question you may have in this regard. So I will now move forward to the last important provision, relevant provision of a sale agreement, which is the applicable law and choice of forum clause. With regards to the applicable law, it is always the same question. So I choose Chinese law or a third country law to govern the contract. In our case, that we have been putting ourselves today, in which I am the seller. If I am a company interested to sell my products in China to a Chinese partner, what I want is for my Chinese partner to pay. So in this case, Chinese law is usually more effective in credit collection if we need to act against a Chinese company. So especially in order to enforce the judicial decision that we may have. So in these cases, we strongly advise to, sorry about the noise of the phone here. In this case, if I sell, I suggest to appoint China as the competent jurisdiction, and also to designate Chinese law as the law to govern the contract. If I am in another scenario, then we may consider to apply a third country jurisdiction for the law, and also for as the entity for to handle any dispute over the contract. It may be Turkey, and maybe the European Union, it may be common law countries. You may decide that, but it should be analyzed. This must be clear. This has to be analyzed on a case basis, based on the performance of the contract and the expectation we have with Chinese partner, obviously, because this will be subject to negotiation as always. And whether to decide to appoint a competent court or an arbitration institution. We will see more details about the cons and pros of each option, but mostly arbitration is advisable for high value or very technical or complex contracts. Otherwise, we usually recommend ordinary courts in China, which are faster, reliable, and more reliable than usually perceived by foreigners. I think this is something that I have commented with my colleagues in China very, very commonly, that the perception that usually foreigners have about Chinese courts are much worse than it is actually how actually is, because like I said, they are faster and more reliable, and at least especially in first and second tier cities. If we are in different cities now, but if we are developing our business, we are gonna point the courts in Shanghai, Beijing, Guangzhou, Shenzhen, Chengdu. So there are a good few of cities in which the courts and the legal system works very well and efficiently, especially. So choice of forum clause, just this will do this distinction between litigation in mainland China and arbitration. So you may choose one of these options. Just the pros and cons of litigation in mainland China, like I said, is legal procedure quick and efficient. We may have a decision for the first instance in 9 months, and usually they stick to this period, so we may rely on that, which is a very, very efficient period. The enforcement can be eased by pretrial preservations, and there's a good legal quality of decisions on average. On the con side, well, the official fee has to be paid by the plaintiff. The official fee is usually a percentage of the amount claimed by the plaintiff. It is highly formalistic system. this can be a setback when making the decision, because it is true that we will need to provide a good volume of evidences to prove our rights. The damage award is still sometimes too low, even though it is actually improving a lot, and we have seen courts awarding very high compensation to foreign companies in the last 1 to 2 years. So the system is changing in this regard. Finally, it is not possible to accumulate litigations if there are different parties or different causes of action. So in the case of arbitration, well, we have two main arbitration institutions in China. One is the China, the Arbitration Commission, and the other one is also in Shanghai or Beijing Arbitration Commissions. These two are very very reliable and international institutions. So it can be a very good option if we decide to conduct the arbitration, appoint an arbitration institution in China. I always would like to mention because we have seen in many contracts entered into by clients that there's a dispute, and we see that the client has chosen by himself to appoint the arbitration institutions in Hong Kong or Singapore to handle the dispute over the contract. We have to be very careful with this, because it sounds very well, it sounds very reliable, the arbitration institution in Hong Kong or Singapore or London or Paris in Europe, for example. They have very good professional, very high qualified technicians and professionals. But we need to be aware of the fees that these kind of arbitration proceedings will cost. And therefore, these institutions are only advisable to be appointed if the scale of the contract is high. It's a large contract. In those cases, okay, we may appoint these institutions. But if not, we are talking about that in Hong Kong or Singapore, an arbitration procedure may cost around $200,000 US at least. So it is important that we keep that in mind when we appoint these institutions in these countries or in these territories, because we may see ourselves in a position in which I cannot enforce the agreement because it will cost more the arbitration procedure than the compensation that I will obtain from the arbitration. So, well, you have also some specific mention here about the arbitration procedure that you may take a look to it, but mainly it is just like I already said. So I let you to check it after the presentation if you want, as you will have the PPT. I will move now with the contract negotiation tips that I'd like to give you, because this can be quite useful and interesting for you to know when facing a negotiation with a Chinese partner. So the first one will be knowing your counterparty. I already mentioned it. So all these preliminary checks that we have to do about our business partner, potential business partner, before we conduct a face-to-face negotiation. The second point would be was just highlight that in China or Chinese culture, especially if we are in a business environment, formalities are very important. And probably not more important, but the Chinese give this importance to the formalities when doing business with foreign partners. For that, we need to be aware of that. We need to be aware that we have to keep these formalities, and there are certain steps and rules that should be followed. For example, writing an email to your counterparty with a kind tone, making a brief introduction and describe the main purpose and context of the transaction before the face-to-face negotiation takes place. And obviously this may sound obvious, but it is not that obvious in China, and it is important that we keep it in mind and we act in this way. So My third point will be a small talk. So if you are going to meet up face-to-face with your business partner, so we are always at that step. According to Chinese culture, a good beginning always comes to the food, and it always goes like that. I know food is important and it is beautiful everywhere, but for Chinese business or in a business environment, food is really crucial. So we will go on a business dinner and we will just try to follow certain indications, rules that have to be followed when conducting this business with the Chinese partner. So initiate, for example, a small talk to warm up the negotiation for a few minutes before the food is served can be a good way and will make the Chinese partner feel close or warm to you and will ease the path to get into proper business negotiation later during dinner or after dinner is finished. Furthermore, I will highlight how important it is to describe the cooperation plan in detail. And I have stressed here the word cooperation because it is for the perception, for the feeling of the Chinese partner. They will make them feel better if we always term or speak in terms of cooperation. And not merely saying that, okay, this is just my distributor in China, or this is just the person that will sell my products in China. No, let's put it in that way. Let's try to involve the Chinese partner into the plan and make them see and believe and feel that it is a cooperation what we are doing. It's all about gaining his trust, and trust in China, it is not that common as we may perceive it in Europe, for example. It has to be gained, and this can help a lot to win. So provide flexible method of quotations. This can be another way just to ease the negotiations. So generally, the quotation of goods is the most concerned point for Chinese partners to do the negotiation. And give them the feeling of your willingness to apply special discounts and that will ease any agreement. It may sound obvious, like I said, but sometimes these obvious points in China are essential for the development of the negotiations. Just to give you an example, you may provide a quotation first for the product, but also later remind or kindly note to the partner that such quotation can be changed based on actual needs. And equally, if the volume of sales are large, you can give a package price, as most Chinese entities prefer this way always. So for large equipment, in practice, the buyer will not purchase large volume at first. Thus, we may discuss the possibility to grant certain discounts in the future when we see that the operations, the activities are going on very well. So just finally, to end up the presentation, so what to do when things go wrong? Well, the step that everybody needs to face. Fortunately not, but sometimes, unfortunately, in when conducting business in China, we see that this is something. This is an end that we see too many business. So we have to be prepared for that. We don't want things to go wrong, but we have to be prepared for that if it finally happens. And how can we be prepared? Well, there are a few steps there that can be done during the contract performance, during the operations. So what practical tips we can keep in mind? Every modification, for example, related to the performance of the obligation should be notified in writing by registered email. This is just for you to keep in mind during the contract performance. It is something that, obviously, like I said, we don't expect things to go wrong, but we have to be prepared in case this happens. And for that, following these simple rules or tips will help a lot to obtain a good outcome in case we see ourselves in a litigations, which is many times just happens. So, for example, also emails are evidence only if notarized. So in case we are going into a litigations, finally, we will have to notarize the emails exchanged with the counterparty. Bad faith matters. Keep this always in mind. So always send the emails to the other party to prove their bad faith. So many times the evidences that we can obtain to prove the counterparty bad faith are on emails, and we have to keep that very well, and we have to be aware of that, and if we need to later use it. So the statute of limitation, which is 2 years, written communications are necessary to interrupt it in case there's a breach of the obligations in the agreement. We have 2 years, even though well, now it has been extended from new civil law to 3 years. And just to give you a practical example, both your and the receiving email address will be recognizable. And again, this may sound obvious, but it is not that obvious in China, as many Chinese partners or use this kind of emails that you can see here. qq.com with some numbers. So here we cannot recognize who is sending the emails, especially because it is signed for as you know, if you have been dealing with Chinese partners before, they tend to use English names. So it is very common in China for business partners to use this kind of email address and try to push your partners to use recognizable email address only. So finally, just if we see ourselves, these were tips for you to keep into account. And if we are under a commercial dispute, well, what can we do? We can do evidence collections. It is essential to collect evidence following certain formalities, like we say, if we see ourselves involved in a contract dispute in China. Delivery provisions of products should always be traceable through original documents on paper, signed or chopped with the official chop, like we said before, by the other party. Delivery documents should state very clearly like we said, the purchase order or sale order, exact product name, quantity, date, or the reference number, and the provision of goods, signed receipt of delivery and notifications by emails to the other party are essential. So if we deliver the goods, we need someone or we need the importer to chop it or to sign it, so we have that evidence. And it is important for you to know that the courts will not consider copies of the contract as evidence. They must be in the original paper and chopped with official chop of the counterparty. I mentioned in the beginning, but I stress this now because it is important in case things go wrong. Enforcement actions, just, well, there's not much we can say here about just the options we have. If things go wrong, then we have to see that or we will get legal advice, evaluate the situations and evidence of the counterparty infringement. We need to count on and define the strategy to put in motion any action to defend your rights and interests, obviously. And what can be very useful is the delivery of an attorney's letter from a Chinese law firm. It can be sometimes very useful, and we have seen that from our experience. And we also be compared to the delivery of this attorney letter to request the comply with the obligations sent from well, a law firm in Chinese or in Europe or in other countries. When Chinese partners, they see about their business partners in sending an attorney's letter from a Chinese law firm, they see that they can be at risk, and they see that the business partner has the legal advice in China to act against them. And this is sometimes a way of pushing them to comply with their obligations. So some Chinese companies take advantage of the usual lack of knowledge of foreign companies about the Chinese legal system and practice and think this foreign partner will not take any legal action against them because they don't know China. This is a very common sentence used. So thus, they don't feel compelled to meet their obligations in the contract. And this is a way we can avoid that. Like I said, submitting then an attorney letter from a Chinese law firm will put some pressure on them and make it understand that his foreign partner is duly assisted to act in China, aware of his rights and willing to defend his interests in China. If none of the above works, well, we will then be forced to file a lawsuit against our business partner as a result of the breach of his contractual obligations. And finally, the applicable law, like we said before, and choice of foreign allies above will determine the court or arbitration institution which will have the capacity to handle the litigations. Just a very quick mention to the fraud cases, because to give you an example, this was a real case when a client was doing business in China with a Chinese company called OUA Pipe and Fitting. And then another company with same name was set up in Hong Kong. And this Hong Kong company contacted our client pretending to be the Chinese company, the partner of our client, and asked for payment to a different bank account. So our client paid, and they later found out that it was a fraud. So my recommendation at this point would be for you to always double check with your partner by means of a different communication channel, by WeChat, by WhatsApp, whatever other communication you may take, before conducting any wire transfer or payment. So because it is the only way we can have to avoid these fraud situations. If we find anyway ourselves under this scenario, get immediate legal advice, which in this case, timing is crucial. And the cooperation with your business partner can also be very helpful to deal with local authorities to get them involved in the case. Also, diplomatic assistance from consulates can be, in this case, is very helpful as they can provide additional resources. Finally, to put an end to my presentation, I always like to finalize these presentations with this set of rules of business in China, which is a wide summary to say everything that we have been commented about Chinese culture, about Chinese practice, about Chinese mindset, but summarized in 8 sentences. No? And it says just that everything for you, if you have been conducting business in China, you will already know. And if you haven't, it is a good thing for you to take into account before entering into business with a Chinese partner. So everything is possible in China, but you must be aware that nothing is easy. Patience is the key to success. No matter what happens, patience is crucial in China. Especially for those of us who has been living there, and you see the importance of this work. Be aware that the answer, yes, is not necessarily an indication of agreement or confirmation. This is important because it can help you to double check always you receive a yes from your Chinese partner, and try to find more inputs or to analyze if there is something behind that yes, because sometimes, many times in some cases there is. Provisional regulations means the rules can take at any time, even retroactively. Signing a contract means the beginning of the real negotiation. In practice, this is something that we lawyers here in China see every day. So every time that we have the contract signed, we have an issue, or we see someone changing the conditions. And when you are optimistic, think about rule 2, nothing is easy in China. And when you are discouraged because everything is too complicated, just think about rule 1, that everything is possible in China. So, well, this is all from my side. Thank you all for attending this webinar. I hope it wasn't too long, and especially it was useful for you and it was interesting. Sorry about the noise with the phone. I couldn't avoid it, and my apologies for that. And now I will be happy to go to the Q&A section and answer all the questions you may have.
Thank you very much, Daniel, for this insightful presentation. It is true that legal and commercial issues are not always an easy topic because there is so much to talk about. There's so many case studies you can make reference to, and we want to thank all the participants to bear with us. Daniel, you covered very well all the topics we wanted to include today. If you allowed me to summarize, I took few notes from my humble experience. I think one of the last things you mentioned, patient is the key to success. I can totally agree on that. We have to all understand the importance of cultural differences that apply also to the business environment, and how important is to understand that the partners you're talking to have a different cultural and business background. And in the case of China, building up a relationship at a more personal level is essential, and this takes time, and visits and negotiations and meetings and after work dinners and KTVs, and it is as important as sitting down around a table and discuss the topics. And I think currently with the COVID is a difficult thing to do, but again, just being insistive and trying to keep on discussion and communicating with the partner is the key to that. And again, building a relationship with the partners you have in China. We have actually quite a lot of questions, Daniel, for you. I hope my summary allowed you to get some water and to get ready for that. So
Yes.
without further ado, I will start reading them.
Okay.
We are going to follow the chronological order. So I hope there is enough context in the questions that allow you to understand what the participants are referring to, but we will have time to discuss this. So I will start. The first question from one of the participants is, where can we get the blacklist?
Well, the blacklist is can be checked with the authorities in China. It is let's say it must be requested, and also it is not available in a public server or in a public source, let's say, but it can be requested through the proper authorities. So sometimes for this you will need the assistance of a firm in China to obtain and to check this information. But it can be checked, which is the important thing in this case. So probably the best thing you can do at this point is just to contact your business partner in China or a firm that can assist you in this regard and conduct this check.
Okay, great. Somebody is also asking, what is the source or the web in order to check or perform the company background?
Well, there are many. There are different sources. Like I said, there are public sources. There are private sources. Some of the private sources, or most of them, are require subscription and payment to obtain the information. Some of them are public, especially to obtain the corporate information. Well, I guess if they specifically want to obtain the link to access this public website or even the private platforms, they can send me an email. I think my email address will be in the presentation, so they can send me an email and I will be happy to send them some platform where they can check the information. Like I said, this information is only available in Chinese. Well, but at least they will have the chance to go through it.
Thank you. The next question relates to the company chops. Is the company stamp or another official authority stamp like the Chamber of Commerce? I guess here they relate, probably the Chamber of Commerce usually have an official stamp similar to what they have in China.
Yes, but my point was for the companies to be aware of the importance of the Chinese company chopping the contract with the red stamp, with the official stamp of the company, and even though we may have, or they may obtain the chop from another official authority, where it is important and where it is essential for the legality, for the binding process of the contract or the binding effect is that the contract is chopped with the official chop of the company. So the company that is a party in the agreement, and I think that that is what should be kept in mind.
Indeed, indeed. Perhaps we can mention here that it is the authorities in China who issue this stamp, this chop. So it
Yes.
has a very formal validity, different to what it happens in Europe.
Absolutely, that is a very good point, Laura. And actually, it is the police who issues the stamp, and that is why the value, its value in China is so high. It's like a precious. And therefore it cannot be easily faked. And if we have the contract chop with the corporate official chop of the company, then we may rest assured that the contract will be binding and about its validity.
And the next question is actually still referring to the chops. Somebody is asking whether there is a way to check if the number of the chop or the chop itself is fake.
I think the best way to say, well, we will not see the chop. What we will see is the red stop stamp in the contract. So in that information, we can see clearly the Chinese name of the company. And by checking this name, we will be able to obtain a lot of information, like we mentioned in the presentation, about this company, about the status and the nature of the company. And we can see whether it is duly incorporated or not, or it may be a fake company. It is not as easy just because of the chop in the contract to tell whether or not it is fake. Even though sometimes it happened to us that we saw that chop could be not reliable, and we advise the client to ask his partner to chop it again or to provide more information about the company. But usually checking and conducting a research with the name of the company will be quite enough to obtain very useful and reliable information.
Thank you very much. The next question relates to the agreements, the contracts themselves. Somebody wants to know if it is possible to decide whether the English version of the agreement will prevail in case of bilingual agreements.
Yes, indeed, it is possible. No problem about it. But like everything else, it will be subject to negotiation, and usually Chinese partners are a bit reluctant to accept that the English version prevails. But even though it can be an object of negotiation, and it can be stated if it can be finally agreed with the client.
Okay. There is another question about the chop. If both parties agree that the contract is governed by other than Chinese law, for instance, British and Turkish, is the chop still required?
It is still required, even though in those cases the arbitration court or the arbitration institution or the courts may not raise any issue about that. But as we are dealing with a company duly incorporated in China, governed and regulated by Chinese laws, and Chinese law says that the binding effect in a contract is only provided by the chop. So we should be aware of that, and Chinese laws will apply with regards to the corporate matters of that company. So even though an international corporate, an international arbitration institution or court may not raise any issue about it if the Chinese partner just signed the contract by the legal representative, it is still advisable to include the chop in the contract.
Okay, thank you very much. We continue with contracts, somebody wants to ask, and I think this is an easy question, is it valid as a contract, something that is not officially a contract, but it could be just a text, such an email or a confirmation order?
It will mostly depend on the content of that email. It can be. I would say it's not very reliable, and it will be very difficult to enforce in a Chinese court, for example. But it will mostly depend on the content. If in the content of the email, if we can have that email notarized, we have all the information necessary to form a contract. So it includes all the elements required to form a contract. We may say, or we might say that we can have a chance to enforce that before a court. But anyway, this will be extraordinary. And as a rule, Chinese courts will require an original contract chopped and signed by the parties. So it is better to keep that in mind, even though there can be options in which well, it can be defended the interest of the client if they only have an email with a counterparty. But it needs to be analyzed on a case basis, and especially the content of those emails or those documents exchanged between the parties.
Okay, next question refers to legal procedures. What is the legal procedure, how long it takes, and how much can cost if we are talking about violation of the intellectual property?
Well, it depends. It depends what kind of violation of intellectual property we're talking about. The options can be many. Let's just say that how long. If what we have to do is to let's take as an example a trademark, because it's the most common issue that companies face in foreign companies face in China. Let's say that we have to well, we've found out that a Chinese company registered our trademark, and we have to cancel this trademark and register our trademark afterwards. In those cases, we are talking about proceedings that can last around 9 to 12 months. The costs are not too high if we can obtain a successful decision in the administrative state, because the cancellation of a trademark remains within an administrative proceeding. So in those cases, it can be effective that we follow the administrative procedure. In 9-12 months, we can have that trademark cancelled and the registration of our trademark if we are successful. And the cost can be, well, I wouldn't say inexpensive, but not too high. So just to clarify, because I'm reading now the question, that it is necessary to file a lawsuit. No, it is not. If we are in the case that I just mentioned, if otherwise we have our rights already protected and registered in China, and there's an infringement of or violation of our rights, then yes, we may have to file a lawsuit for the infringement of our intellectual property. And in that case, we will be under a judicial procedure before a Chinese court. Or we can also take administrative measures of enforcement if we want this to stop the infringement of our rights. In cases like, well, it can be requested raids, for example, to the police in China. If we have enough evidences to prove infringement, we can go also to the police in China and with our certificate of registration of trademark, for example, and request a raid action against the infringer in, for example, a warehouse where we know and we have detected that the infringing products are stored. But like I said, this intellectual property in China can be, well, it's a field that can be, well, can be discussed in a whole different webinar, and we could be spend hours talking about it.
Yes, indeed. Here, I would like to also make a remark that for the very first steps of the IP protection, we suggest you also to refer to the China IP SME Help Desk, which is another EU-funded project targeting China. They usually offer first-hand consultation services regarding trademark registration, although of course that once you decide to register your trademark in the Chinese market, you might need the support of a law firm such as Daniel's law firm. Continuing with the next question. Now we are talking about warranty period. Somebody wants to know a little bit more about the warranty period and warranty replacement after 3 days.
Well, in this case, after 3 days of delivery, I believe, because this was the, well, I'm not very sure about the specific question, but anyway, what we have to keep in mind is that the warranties will depend on the product warranty provided by the seller, and this may change from one product to other. So there's no anything fixed or set in advance. And the warranty that I mentioned in the contract was actually limitation of warranty. So the seller only advised or only accepts the warranty is limited to the replacement of the products, but this will be subject to negotiation with the counterparty, with the Chinese partner, and that will be taken into account. The differences, the options may be very, well, a wide range of options. Then this is a complex matter, and my advice would be to obtain legal advice for that, because it needs to be carefully assessed.
Okay, thank you very much. Next question. I will say here is very wide. Somebody wants to know about lawyer experience when going to court. I believe that we can organize a full webinar talking about different experience. Perhaps we can leave this to the end if we have some time. Then I jump into the next question, and it relates to automatic legal protection by the Chinese government. Does this exist? Is there a mechanism from the Chinese government, or you still have always to initiate an action towards the authorities, or with the authorities towards a partner in case of intellectual property violation?
No, it's I never heard about legal protection, automatic legal protection by the Chinese government. I don't think such a thing exists. What it does exist is the usual channels and procedures we have to follow to protect our intellectual property. So to register our trademark and patents or whatever IP rights we are talking about before the competent authorities, which in this case will be the China Intellectual Property Office. So if we have those rights duly registered, we have protected our intellectual property rights in China, then yes, obviously, according to the laws and regulations, the corresponding protections will be enforced, but as anywhere else, as any other country where we have protected our rights. So this should be no different in China.
Correct. And here perhaps we can emphasize how important it is to register your trademark before starting even talking to any partner, not only in China, but anywhere in the world.
It is essential, absolutely. It's a very good point, and I think it is not always considered, and the importance of that by foreign companies when starting their business in China. It is essential, and it is a way to avoid further issues in the future.
Indeed. Here we have another question. Somebody considers that arbitration usually is very costly, and is there any other or more appropriate form of legal protection for SMEs?
I think I already mentioned this, and yes, arbitration can be very costly, and especially, like I said in the presentation, if we appoint the arbitration institutions of territories like Hong Kong, Singapore, or even the courts in Paris, or international arbitration institution in Paris or London. So my advice, if, like I said, if we are dealing with a Chinese partner, and I am the seller, should be to appoint Chinese courts to handle any disputes over the agreement. Because I think the legal or the judicial practice in China is much more reliable than how it is perceived by Western countries and by Westerners in general. So our experience is that we can rely on that to have good judicial decisions. So that would be my advice for SMEs, companies in that case, if possible. If not, well, yes, obviously arbitration institution, but even international arbitration institution in China, like the one I said, that the China Institution Commission and Shanghai Institution Commission, can be a good way and not that costly to handle any dispute we may have over the contract, or the performance of the contract.
Indeed, here it's important to mention that since in the past few years, actually, we have seen the Chinese courts being more and more professional and responsive towards this kind of IP infringement and also supporting international or foreign companies in these endeavors.
Absolutely, yes. Yeah.
Perfect. We have somebody asking about online channels. If you're selling online to China, but you still have partners and you have to discuss contracts, and obviously in this case there is no chance to meet face to face, what is the best way to actually start negotiating with a China partner?
Not easy to tell if we are on an online environment only, if we are limited to that. And unfortunately, nowadays, that is the situation. So I guess the path is a little bit more complicated for companies. But like I think you raised this point before, you mentioned to develop this personal relationship. So even if we cannot meet face to face, I guess we have all the tools nowadays to conduct these Zoom calls, to do the phone calls, video calls, and we try to develop the relationship besides the business environment. So even though we cannot meet face to face, there are other ways, other channels that we can take to promote that and try to offer new ways of collaboration.
Indeed, and actually one of the things that has happened with the COVID is that everybody has somehow to adjust to the digital format, and this obviously
Indeed.
affects also to Chinese. And actually we have heard of many relationships that have been built in the past years through digital channels such as Teams, Zoom meetings, and we have seen a change in the way we are communicating and dealing with China. And I believe, as Daniel said, this shouldn't be an excuse not to develop a deep relationship and understanding who you are negotiating and engaging with. Indeed. Okay, I'm just reading the next question. What do you think about mentioning arbitration in Turkey on contracts? We as seller try to guarantee our position in case of any dispute arises, but is it applicable in practice in Chinese contracts?
Well, I mean, the arbitration institution that we appoint in the contract to handle any dispute over the contract will be the one to which the parties will have to go to get those disputes solved. My point here would be more that if I need to enforce the decision or the arbitration award against a Chinese company later, I will anyway have to go to a Chinese court to do it. So if that is the case, I would advise not to appoint an arbitration institutions in a third country, but doing it in China. Like I said, if the case is different, if we are maybe the buyers, we may choose a different law applicable to the contract and also a different method to solve disputes in China, in the contract, sorry. But this anyway has to be analyzed on a case basis and analyze what are the cons and pros of each option based on where the contract performance will take place, nationality of the parties, and different aspects within the contract. So it requires a deep and specific analysis.
Thank you very much. Somebody is asking again, which authorities provide the blacklist? We already replied to this. Just a brief mention, there are several sources, and if you want the specific details, you can reach out to Daniel, that he will disclose further information. I just jumped to the next one. What are the accredited quality control companies in China for product quality control when necessary? I believe that this refers to controlling the quality of the products that are being purchased, I assume, in this case.
Yes, I think so. But this can be well, this require a full explanation. It can be very long. Just let me mention that well, there are institutions, there are firms in China that can provide these services to conduct this product quality or quality control assessment when delivering the products. So we can get the assistance or services of one of these companies. But my advice would be to, like I said in the presentation, to regulate that proceeding precisely in the contract. And then if we need assistance from a third party, there are institutions, there are firms that can do that. So we can rely also on that. If I can provide a list of firms that can provide these services, I can help with that if for whoever needs. So if the attendees can send me an email, I will be happy to reply them with that information as well.
Okay, and since the time is up, we will just choose one last question. For those we haven't replied, I will coordinate with Daniel to give you a separate feedback by email, as we have everybody's contact details. We apologize, but the time is limited, as you could see. Somebody is actually referring to something we mentioned before. Shall we ask Chinese partner to get a notarization on their emails? I assume this refers to what we mentioned before, that sometimes an email and a document that is not a contract can be enforced as such. And somebody is asking whether a notarization might help in this endeavor.
It may be a good point. I'm not sure. The problem I see here is that if we, in the beginning, ask our Chinese partner to get notarized their email, they may have some suspicions, and why are we asking that? No, it may not be the best way to approach them initially. We can do that later. But anyway, I only think it will be necessary to notarize it in case we are under or we are already in the contract performance and we may have some issues and we see that this well can end up in a litigation, for example. In that scenario, yes, I would advise or recommend to notarize, to have those email notarized. But if not in the beginning, I think just by mentioning our partner that we need them to reply us from the corporate email address, that would be enough. It is just so the important thing, like I mentioned, and the example I use in the presentation, is just to have a clear understanding of who is sending that email, and it comes from an email address of the company we are dealing with. And if those details, that information is recognizable, then it is usually quite enough.
Okay, well, thank you very much, Daniel. Thank you very much, the Istanbul Chamber of Industry, for being our partner today. Suleiman, I don't know if you want to share any additional comments for my side. I just want to remind everybody to please take 5 minutes to fill up our survey. Because it's extremely important for us to get your feedback, to know how you like the content of today, and also, again, to know what other topics you would like to learn about. Thank you, Daniel, for this amazing presentation. And Suleiman, I leave the floor to you.
Thank you very much, Laura. On behalf of Istanbul Chamber of Industry, I thank Daniel. He explained a very extensive law topic like sales contracts in a way very comprehensible for everybody. Thank you for your presentation, Daniel. And thank you, Laura, for your moderation and the team for organizing this event. We are looking forward to make events with you in the future, if possible. And for the for our Turkish participants, we already made an ICI Istanbul Chamber of Industry China help desk. Just Google ISO Çin Masası for details about our events now going on. Thanks everybody for participating.